what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So, it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory.
Well, I had to click some buttons to figure out which ones to get on. Hey, it's Gonzo. Welcome, everybody. A little show that I'm going to be putting on for you guys today. Solo Gonzo. Hello, ride-alongs. Hello, road dogs, ground pounders, everybody that's supporting the cause. Welcome to Saturday. Yeah, Saturday's show. It's going to be pre-recorded, but hey, listen. A lot of stuff has been dropped, and like per usual, Brian and I are always behind the 8 ball, but we're trying to catch up as schedule allows. But with 6 hours of that stuff, and a lot of information was dropped, and a lot of information was covered right by a lot of the YouTubers out there. But one thing that I was noticing is when Bev was asking questions for the defense, it almost came a little bit more like hostile, more aggressive. So what you're going to watch is I try to capture all of the interactions with Bev, with the prosecution, Bev interacting with the defense. And I don't know, maybe it's just me. Maybe it's just me. But it sure seemed like she was a lot more aggressive and a lot more hostile, asking a lot more questions of the defense than she did with the prosecution. So we're going to roll this. It's like the title says, against all odds. Man, the defense, they're fighting an uphill battle with these two. So let's see what happens. Let's roll it.
On March 20th and 22nd of last year, roughly 2 months before the ARCA witnesses testified. There is another email that was 2 days before the trial and after the voir dire, 2 days before the trial with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCA witnesses were expecting to get paid. So the Commonwealth, I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people. And that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails.
Hold on, let me pause that for a second. She wanted to take 3 days off so she could let the defense get information, gather their statements so they can make an argument. Okay, I get that. So she could also read up on it as well. And I think maybe even to give old Hanky Panky more time to develop an argument that the defense is going to bring up. And I do believe they received like 3,000 new items of information that they were going to have to get through as well. I could be wrong. There's a lot of numbers in this damn court case, but let's carry on, boys and girls. Let's go.
So it made sense to me to suspend first and foremost for that reason. So counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not one, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first.
Wait a minute. So what they talk about on the sidebar, correct me if I'm wrong, can be used as evidence? Or am I misunderstanding what she said? Because if that's the case, why don't they just hot mic the sidebars, right? And I could be wrong. I'm a guy that's born in Idaho, so the city stuff, I get it, but I don't get it.
But when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be.
She already knows.
I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
Your Honor, thank you for the opportunity to be heard. I am going to be responding on behalf of defense counsel to all of your concerns. I have a notebook that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing, transcripts, documents, probative issues. And if, with Your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed to you, bring it up?
A court officer will take it for you.
Okay.
I appreciate that, Mr. Lessie.
You're welcome.
Mr. Lessie. Let's go, boy.
Thank you.
Let's go, boy.
There's another notebook to follow along. And with that, Your Honor, I'm going to go to the podium and make my presentation.
Okay. You know what? Actually, I'm going to take 5 minutes to just quickly go through this.
That would be excellent. Thank you, Your Honor.
So she took a few minutes, well, probably half hour to an hour, to review that notebook because she didn't want to get caught off guard. I'm assuming. I don't know. Right? If you're going to be following along and you're going to be impartial, it wouldn't matter what's in there, right? You just go along. You just follow what the defense is going through. Huh. Stinky.
All right, so I apologize if that wasn't quite 5 minutes. I just wanted to see what it was that you had there.
Are you comfortable with what's in the notebook?
Yes, if I haven't read everything, but I know what each of them are.
Table of contents.
Yeah. All right, so you were addressing this in chronological order as well, right? So if you can tell me those pages now, I'll likely recess because I do want to see them before you talk about them, but I'll hear you going up to that point. So what pages are those?
And you're referring, Your Honor, to the February 18th transcript?
Yes,
Yes,
your
I will
number.
tell you exact
8.
pages that I'm going to refer to. And Your Honor, get to the, this is tab 8
Right.
in the notebook. Mm-hmm. And specific pages that I'm going to reference start on page 53.
Okay.
And those are 9 pages that proceed all the way to really the substance ends on page 62.
Okay.
And I appreciate me testifying. That was the
Was the federal protective order that was referenced by Ms. Giannetti that said it was specifically outlined and ruled that they could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question directly.
I'd like you to answer my question.
Yeah, the ARCA experts in his opening.
I did not review the openings. I reviewed only, for the non-evidentiary transcripts I reviewed, was only Mr. Jackson's closing argument.
Certainly fair enough. In support of the
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can hopefully get it.
I can find it. I didn't know if you had it.
So, and I want to key into your words, Your Honor, because I want to be fair and precise. Your question.
That's exactly what I said.
You know what I noticed when I was watching this the first time is that every time the defense was going to start rolling and start hammering out some points, what was the page number? And he'd throw him off for a second. He'd like, what? Yeah, it's page whatever. Or, that's exactly what I said. It seems like she's just throwing little dodgeballs out there to make him dodge back and forth. And it's just something that I noticed. As soon as he was going to start rolling, she'd say something. Let's keep watching.
Pardon me?
That's exactly what I said.
Yes. Mr. Wolf prepared the document, not Mr. Jackson.
No, I was well aware of that.
Okay. That very testimony in that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor.
You know what I mean?
What I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom is that Your Honor is on everything. I think that person.
He was trying to butter her up. Hey, you can't be mad at the guy for playing the game, right? Whatever you can do.
Would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you. My speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits, okay?
I will not.
You can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor. And
If you know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate anymore. I said I was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Your Honor, first of all, completely understood, no more speculation. There will be no more speculation until we get to February 18th, what I think is really important.
Okay.
Because the Commonwealth on the 18th speculated a lot. And I think the only way to fairly...
So let's go back to this, okay? You'll get to February 18th. Do you know for certain that that's what...
Okay, hold on. He's right. He's right. Hanky Panky was speculating a little shit ton, right? And she allowed it. She was like, I'm eating it up. But when the defense is doing it, she didn't want to hear it, right? She didn't want it to be out in social media to where everybody can tear it up. So she's not impartial. She's definitely biased.
Dr. Wolf was thinking.
I will tell you the basis of it, in fact. I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolf was, there would be no reason for the call.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand, which I've been alluding to during
Okay, so this is the one I said I needed to take a recess to read
I was just going
that.
to say the same thing.
All right,
This
so-
is now that point.
All right, why don't we take a 15-minute recess?
Speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just, the buildup is all in.
And what was the date again that the defense provided it? The Friday night before our hearing, was it?
Mine. That's not a fact. But that, if that were true, that would be very bad.
So what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll start back up at 2.
Okay, Your Honor.
Right. Do you think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea, and I'm not rushing you, do you have an idea, because we do have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
I'm going to answer your question. I think I can conclude in 45 minutes because I have to get to the law, the 3.3A. I have to.
I'm not rushing you. I just wanted a time frame.
That's my best answer, and I will say this, Your Honor. I share your interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share the goal, believe me.
Oh boy, it's coming well. Oh. Okay, let me pause that for a second. Let me see if I get this right button here. No, wrong one. Yes, here we go. No, I can't remember which one it was. So I want you guys to watch to see how many times she interrupts Hanky Panky. Okay. Hanky Panky doesn't give her, I don't think he gives her any information to follow along with. Maybe he does. I don't know. I can't remember. Maybe he does. I need some King Coca-Cola. But I feel that she was definitely interrupting the defense a little bit more, especially when she had that notebook right in front of her face. So let's watch this and see what happens. Let me see if I get the right one here. Yeah, here we go. Play.
can be seated. We'll be back in a second.
One more thing too. This second part, for some reason, the audio wasn't very good, so I had to turn it up. It might be a little loud on your guys' end if you got in the Bluetooth or if you're watching on the phone. So I apologize ahead of time, and you can hammer me on the chat too. Let's go.
So before I get the call, Mr. Leslie, I am going to take you up on your offer to ask any questions, and I may have questions for both sides next week. But actually, what I want to do, and you said I could ask questions of other counsel. So while memories are fresh, I just want to ensure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Unetti.
Yes, ma'am.
As an officer of the court, is there anything that you dispute that you just heard from Mr. Leslie? And what I'm particularly concerned about is what you knew or what you didn't know.
You know, what he said was entirely accurate.
Okay? Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
Well, I'm sure you looked at it after you looked at the transcript. I did as well.
I did long before I looked at the transcript.
Right. The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript, was very clearly the federal batch of information, what we refer to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small...
Invoices, payment.
No, nothing. Because the context of what Mr. Brennan was talking about, being frustrated about, were his TUI requests concerning the federal batch of information, and that's when I was making the additional statement, we don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
This is the...
No, hold on. Ms. Little, it was just thrown on you that you're responsible for all discovery. But the same question, you again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay. So I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock. But I will hear you, Mr. Brennan.
Attorney Alessi ended his argument talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct in this case, you should consider the history of the case, including repetitive violations, 3.6 violations, protective order violations.
Man, did you see how she was looking at Mr. Hanky Panky? Wow. She's going to hell. Lusting.
And then discovery violations, representation violations. The defense in the first trial, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having ex-parte communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Lewis.
It wasn't a request, Your Honor.
You suggested that I call it.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
So even when he's not doing a presentation, the defense is still getting attacked and hammered. You see what I'm seeing? See what I'm seeing? Do you see what I'm seeing? Yep, I see it.
I'll move on, including ARCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed that everything is done by the book, by regulation, through TUI requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge, essentially, of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask the counsel if there was any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over there, please.
Yes.
All right, if I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with whatever.
May I have a moment to speak to counsel?
Sure.
I'll need to call the United States Attorney's Office and get an answer from you.
All right, I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Day 26 of the trial.
What date?
Day 26 of the
No, I
trial.
know that, but what date?
June 5th, 2024. And those are definitely questions I'm going to ask, so I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? There's date, I'm sorry. What's the volume number and the page number?
Day 26 of the trial, page 248 to 250. I will get a volume number to the court.
That's okay.
This seems to direct...
I've got the transcript. What page you want? Do you know?
No, but I can...
If it's just your notes, that's okay.
I can pull it up, Your Honor. Page 4, line 11, the court asks, so the understanding of the voir dire is that this is for the conversation with the federal government. We have no affidavit, we have no witness, we have no writing, no email, no correspondence, nothing to support.
I think she might be falling asleep. You know how you're awake, but you're asleep with your eyes open? You know, you're just like not in where you're supposed to be in, but you're out. Does that make sense? You're just like in a daze. You're just looking through whatever you're looking. You're not even there. Watch her.
Or put in context the conversation. Nothing. No. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story. A fraction. It's not enough to blame the Commonwealth, blame the U.S. Attorney's Office.
He's tired.
This is accountability.
Falling asleep.
In addition, when we look at the totality of representations made in court, we also, at some point, are going to address the Commonwealth's position of violations of 3.6. That's the motion. It's interesting that after the last court hearing, why did they approve? Why did they...
particular page you might be able to have without sight?
Yeah. If you look at the first page...
Yes.
You
don't have to read any of it. You just tell me the paragraph. Leslie, very briefly, if you have something?
Yes, thank you, Your Honor. I'll be very brief. The court said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right, so you just told that I paid for their time. That was not said, right?
That was not said, but I'm saying there's always some inference about being, it was Dr. Russell was the third one.
Oh, I thought it was the 3 ARCA people. I have to go back to the transcript.
You can go back to the transcript. Earlier on, there was a discussion, way early on.
Who is Mr. Klein?
He was a third ARCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony. He didn't testify.
It's been a long time.
I understand. I'm trying to answer your question, Your Honor.
I know, and I realize that you just said something that you want to explain. Go ahead and explain.
Right. So what I'm saying, you'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you are calling 3 witnesses whom you've never spoken to. When I had that discussion with Mr. Unity, that's what I meant.
Thank you for bringing that up, Your Honor. Attorney Brennan didn't read the rest of it. You're to believe him.
Okay, so where are we? Are we the June 10th?
Yes, please, Your Honor. June 10th. That's exactly right. Your Honor, that's 100% true because I
read that earlier.
Right.
That was filed late, right?
February 6th.
Saturday or something.
February 16, 2025. This sums it up, really. And this is signed by Attorney Jackson, Attorney Alisi, Attorney Minetti, certificate of service by Attorney Little.
Was it signed by Ms. Little? It's not.
Ms. Little has only done the certificate of service.
Okay.
She did not sign it. It was signed by Attorney Jackson, Alisi, and Minetti. Thank you.
All right. So we're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court at 9:30 in the morning.
Okay.
Could we possibly go there and then
Yes.
come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have these all scheduled at 9.
We do.
Okay. All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course I'll let you go to federal court first, and also Friday. All right, so we'll see you next week.
So that's it. Wrong one. That's it. It seems to me that she was more aggressive to the defense, right? Interrupting them right when they're starting to get rolling, Oh, it was a date. You heard me say it. So I don't know. You tell me what you guys think. What your opinion is on that. I just don't think that she's being impartial. I think she's just biased. Well, I get it, right? They're about to lose a murder case, allegedly. And Karen Reed is probably going to sue the pants off these people for everything. And she deserves every penny of it. So anyway, that's today's show from Gonzo, Fun-Sized Gonzo. I appreciate it. And listen, I want to say, smash that like button, share it, and also buy some merch because I think Steve just told me today that we're donating $200 from the proceeds of our merchandise. So click it and put it on. All right. But let me know what you guys think in the comments. You guys do great response on the comments and you enlighten me and you teach me a bunch of stuff. So I appreciate it. I think with all the attorney knowledge that's getting thrown down myself and Brian's throat, we're going to be taking the bar here pretty soon in Nevada. So we might be attorneys. Good luck with that. Anyway, thanks for watching. Appreciate it. Stay safe out there. And remember, do the right thing when nobody's watching. Peace.
1 Sam 5 and 1 Sam 6, copy of 425 call.
Copy. 1 Sam 5 en route.
1 Sam 6, copy, en route.